Plead the case you can plead, not simply the case you would like to plead. Pleadings are more than simply telling your side of the story. It has to fit into a legal framework. For example, there is a world of difference in the legal test to be met in cases alleging wrongful dismissal and unfair dismissal, even though, for some, an unfair dismissal may be deemed wrong or a wrongful dismissal may be deemed unfair. And in terms of remedy, if one pleaded the former, wrongful, but meant the latter, unfair, they may find that rather than receiving, amongst other things, a basic award and future loss of earnings, they are left instead with nothing more than their notice pay, which may be significantly less. Also, for example, regarding matters under the Equality Act 2010, does one mean less favorable treatment or unfavorable treatment? Does one mean direct or indirect discrimination? Is harassment available for the protected characteristic upon which one relies? These are matters that must be addressed before one pleads one's case. Claimant employee and respondent employer. Furthermore, a claimant would be wasting his time pleading that their complaint of unequal pay is based on an allegation that their work is the same or broadly similar to that of a male-female colleagues, when there is no male-female doing the same or broadly similar work in the workplace. A hypothetical comparator does not apply, that is, had they employed a man they would have paid him more. In such a case, what one might have in mind is that, for example, his case is of equal value to the said colleague instead. It also goes for the defense response. An employer would be wasting its time and fail in defending a claim properly where a claimant has pleaded the latter but the defense deals with the former. The claim for all intents and purposes would remain undefended in law. Ironically, not all characteristics are protected under the Equality Act 2010 in the same way. For example, the concept of comparators applies to most but not to all, whereas the concept of unfavorable treatment applies to a few but not to most, and the concept of a discriminatory act of dismissal necessarily amounting to automatic unfair dismissal hardly applies at all, but it does apply. And, as for harassment, all protected characteristics save for the said one that attracts automatic unfair dismissal applies. The concept of indirect discrimination does not escape either, where, naturally, it applies to protected characteristics but not to all. And I won't even touch on the concept of combined discrimination, dual characteristics that has its own omissions. It is, therefore, unsurprising that the layperson gets confused by how best to present their case or, sadly, miss out on presenting their case properly. Obviously, this brief article does not seek to deal with all the above. Specific legal advice should be sought where required, but I shall use one protected characteristic to emphasize part of the points raised above. Take, for example, the protected characteristic of pregnancy and maternity. As early as S.4 of the Equality Act 2010 we are introduced to the protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. As most would suspect, it is not enough for a claimant to complain that they have one or more characteristic that is protected under the 2010 Act and, therefore, they should win their case. Usually, one has to show, initially, that they have been treated less favorably than an actual or hypothetical comparator. However, such is not the position in the case of discrimination against a woman because of her pregnancy or of illness suffered by her as a result of it. The issue of protected period is not relevant to the point and, therefore, not addressed, because she is on compulsory maternity leave, because she is exercising or seeking to exercise, or has exercised or sought to exercise, the right to ordinary or additional maternity leave. In this case, the applicable concept is not one of comparison. That is, a person, A, discriminates against another, B, if, because of a protected characteristic, A treats B less favorably than A treats or would treat others, but simply one of unfavorable treatment. Notably, the concept of unfavorable treatment applies also in cases of discrimination arising from disability. In harassment cases, it is frequently overlooked that an employment tribunal, ET, has no jurisdiction to hear cases involving standalone allegations of bullying and harassment. For the ET to have jurisdiction, the harassment must be unwanted conduct related to a relevant protected characteristic, and the conduct has the purpose or effect of violating one's dignity, or creating an intimidating, hostile, degrading, humiliating or offensive environment for one. However, the characteristic of pregnancy and maternity is not a relevant protected characteristic for the purposes of harassment. Therefore, Currently, a woman cannot present a complaint of harassment to the ET that was based on her pregnancy and/or maternity. I shall touch briefly on indirect discrimination. I shall not explain this concept fully as that would necessarily entail discussing the concepts of a provision, criterion and practice, PCP, that appear to be neutral on their face but when applied to the claimant and to those with whom the claimant does not share a characteristic puts or would put the claimant, or those with whom the claimant shares the characteristic, at a particular disadvantage when compared to those who do not share it. In such a case the employer would be deemed to have indirectly discriminated against the claimant unless it can show the PCP to be a proportionate means of achieving a legitimate aim. Again, the characteristics in question are all those mentioned in S.4 as referred to above but not to pregnancy and maternity. Therefore, currently, if a pregnant woman and/or one on maternity leave feels that the application of a PCP puts her at a particular disadvantage when compared to women who are not pregnant and/or not on maternity leave, she cannot present a complaint of indirect discrimination on that basis. Finally, much of the above show what complaints cannot be raised. I finish on what can. Unless an exception applies, one cannot present a complaint of unfair dismissal unless one has been continuously employed for at least 2 years. So, if one feels that their dismissal was because of a protected characteristic but has less than 2 years continuous employment, they would present a case of unlawful discrimination but not unfair dismissal. However, in the case of pregnancy and maternity discrimination, the need for 2 years continuous employment does not apply. Therefore, in such a case, that is one of dismissal, the claimant can present a case of unlawful discrimination because of the pregnancy and/or maternity in addition to a complaint of automatic unfair dismissal. In conclusion, it can be seen from this one area alone, pregnancy and maternity, how complex discrimination cases can be to plead accurately, claim and defense, and to fight, present and defend. Before one pens the claim or defense, it is worth taking particular time to determine how the law applies to the facts in question and what needs to be proven and by whom. In some cases, the burden of proof starts with one party and then, upon a prima facie case being raised, shifts to the other party, but remains overall with the former. Confusing? Maybe. But, to get it wrong could lead to a good case, for claimant or respondent, being lost for technical reasons or on technical grounds that might otherwise have been avoided had the matter been considered and approached properly before rushing into pleading simply how right you were or how badly you have been treated.